Be seated. Good morning. Now's the time set for oral argument in cause number 1 CACV 130400, Nardelli versus Metropolitan et al. For your information, these proceedings are being both audio and video recorded. So barring any unforeseen problems, you can sit back and critique yourself on YouTube in a couple of weeks. Enjoy the moment. Counsel, each side is going to be entitled to 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can avoid taking up all your time. Ultimately, however, your reserving the rebuttal time will be up to you. We have reviewed the briefs. We have conferenced the case. We are well aware of the facts and issues attendant to this argument. You might want to keep that in consideration in regard to how you address your argument and what you present to the court today. And when you come to the podium, I would ask that you state your name and who you represent. With that, counsel, you can begin.
Good morning, Your Honors. My name is Steve Dawson. I'm here on behalf of plaintiffs' appellants Ken and Tammy Nardelli, and with me at counsel table is Richard Dillenberg. I do hope to save 5 minutes for rebuttal. Your Honors, with regard to restitution, MetLife argues, and I'm quoting from its brief, that Arizona courts have no authority to disregard Section 44-1201 and apply an equitable rate, or the rate that the Nardellis actually earned. But if this is true, that Arizona courts decide this issue that rises and falls on the application of 44-1201, then MetLife would be entitled to no interest on the amount of its overpayment of this judgment. Because you have to be confined then to only what 44-1201 permits. In order to receive any interest, it would have to have been determined that the tendered amount was a loan, indebtedness, or other obligation.
Mr. Dawson, I've read the trial record looking for that argument made in the Superior Court and couldn't find it. Where was that argument preserved in the trial court?
Judge Downey, that specific argument about obligation or other indebtedness was not made. The argument that was at issue in the trial court, first of all, it was MetLife who raised the issue. It was not newly asserted on appeal that the court had to apply and correctly interpret 44-1201. So the issue of how does 44-1201 interact with our facts here was squarely before the court.
But if you didn't say to the trial court, it's not a debt obligation under 44-1201, then generally it's not preserved.
Well, Judge Kessler, the reason that I would assert it was preserved in spite of that is that, and again, this is at page 3 of MetLife's answering brief, plaintiffs always argued that the statute didn't apply, and instead argued that no interest or an equitable rate of interest should apply. So it was a fairly narrow argument that we were always dealing with, the application and interpretation of 44-1201. Our focus before the trial court was more on the fact that we're dealing with an equitable remedy, and thereby equity should come in to decide what interest, if any, should be applying.
And that argument was made very clearly, but even in the oral argument, the court was probing the applicability of the statute, and I don't remember if you argued it, Mr. Dillenberg, or someone else.
I did, Your Honor.
Stated that the Nardellis are not disputing that the statutory rate is what MetLife says it is. It seemed to me that in the trial court, at least, the Nardellis were conceding that the statute, if a statute required interest, it was this statute, but it shouldn't apply for equitable reasons. And I think this argument about loan or indebtedness is an interesting one and maybe even a decent one, but I can't find where that was made below.
Well, again, we didn't specifically argue indebtedness or obligation. We did concede that the statute, the prejudgment interest portion of the statute, was 10%. I still stand here conceding that. I'm not arguing otherwise. What we argued, however, is that the court, if you read the language of the statute, was not compelled to follow the language of the statute to apply to our situation. And I'd also point out that, of course, as Your Honors know, the rule of waiver is one of procedure, not of jurisdiction. And it's often applied when the issue involves the interpretation of a statute. In fact, the principle that this court should not be limited to the arguments made by the parties if that would cause the court to reach an incorrect result, this court has said in previous decisions, has great force when the court is considering the meaning of a statute, which is exactly what we're doing here. So it just, see, and this dovetails, I think, so much into, should the court be wrestling with principles of equity, or should the court not even break a sweat on exercising equitable jurisdiction and simply apply the words of 44-1201? I don't know how the case is decided with escaping that issue. In accordance with this obligation, was there an obligation after MetLife tendered the amount of the judgment coming out of the trial court? Under the use of 44-1201 of obligation, there wasn't. By having a judgment against MetLife, it was MetLife who had an obligation to either pay or supersede the amount of that judgment. By definition, a tender is an unconditional, without stipulation, offer of payment. So rather than an obligation, the Nardellis had the unconditional right to receive and use the money. It did not become an obligation or indebtedness before the mandate issued from this court, which was January 28, 2013. In this court's decision of Ramey versus Ditzworth, which both sides cite and discuss a lot, the court held at paragraph 23, entitlement to restitution is not triggered until a judgment is set aside, which did not occur here until the mandate was issued. And here the Nardellis had made restitution 6 months before the mandate issued. Restitution was made in July of 2012. The mandate came down in January of 2013. MetLife's argument that they're entitled to prejudgment interest under the statute on that amount of money would be akin to an action on the default of an interest-free loan, where if there were an action on the default of an interest-free loan, interest would not begin to run until repayment is due, as opposed to the time the interest-free loan funds were provided. Also, this court in State versus Taylor, is actually the Pest Control Commission, State Pest Control Commission versus Taylor, which was discussed extensively in the Metzler versus BCI Coca-Cola case recently decided by Division II and cited in the briefs. In Taylor, it was pointed out that the statute, 44-1201, doesn't contain a definition of the term obligation. And there they found that a civil penalty that had been previously imposed was not subject to prejudgment interest under the statute. The analysis that I believe it was Division I and Taylor used is, again, we're going to apply the statute. We've got to look at the language of the statute to determine what the legislature intended in terms of when it applies. And they likened it to situations of criminal restitution. And the court, your court, pointed out that in criminal restitution, until the legislature said later, they drafted a statute which changed this, that no prejudgment interest was due and owing on criminal restitution. Well, that conclusion from Taylor, which was just decided in 2010, is even more compelling here. Prejudgment interest, as MetLife argues it's entitled to as a matter of right, would not serve one of the two primary purposes that this court and other courts have pointed out as to why a party is entitled as a matter of right to prejudgment interest on a liquidated sum, and that is to deter dilatory litigation tactics. such a consideration would not exist unless and until the judgment is reversed or modified. There was nothing for the Nardellis to do after the judgment was received.
But on the other hand, the bank having tendered the amount, and you're having taken it, it was deprived of the use of its funds. That ultimately it was, you would, I think you conceded that they were entitled to the difference back. The difference between the punitive damages ultimately awarded and the reduced amount by our court. So they were entitled to that money back, and so the countervailing policy isn't true. Is it accurate to say the countervailing policy is, since the bank as the judgment debtor now gets the money back, that they have the interest is to compensate them for the loss of use of their funds?
The MetLife.
I meant bank.
I'm sorry. I know. And I started to say the same thing. Here's what they're arguing, the logical extension of their argument, and I think this might answer the question. They argue that by its tender, as the judgment debtor, they eliminate the obligation to pay interest when it later pays an affirmed judgment, and that they simultaneously create an obligation on the part of the judgment creditor to pay interest if the judgment is later reduced or set aside. They argue to have an interest-neutral outcome, the creditor should refuse the tender, which allows the debtor the use of the funds, or if the judgment creditor accepts the unconditional tender, interest on the funds. If the judgment is affirmed, the judgment creditor has no equitable claim to interest on the judgment amount, even though it has remained in the hands of the judgment debtor, because the judgment creditor could have received the funds by accepting the tender. But they're attaching strings to that, of course.
But that was resolved. It was found to be an unconditional tender, so I don't think you can turn the clock back and argue it was something different.
No, I agree, and I didn't mean to imply that it was not. But by meaning to imply by the argument now, it injects a new dynamic into this. That if the plaintiff, the judgment creditor, had received the funds and the judgment's later reduced, plaintiff now owes interest. The result is the judgment debtor is guaranteed of use or interest regardless of outcome. And this goes back to the purpose that this court has set out in prior decisions about when and why do we say that a party is entitled as a matter of right to prejudgment interest under 1201. And again, one of the purposes is to deter or discourage delay and dilatory tactics on the part of the person who has the money, and you're saying you should be getting that money back sooner. That purpose can't be satisfied
but
here.
If the judgment debtor tenders the money, so it doesn't have to pay post-judgment interest, they have a right to do that.
They do.
And then if the amount gets reduced, if the judgment gets reduced, they still have the loss of value of their money.
They do.
That's the interest. That's why the interest would kick in, right?
Well,
the interest on that loss.
Well, I won't follow you that far, and I don't follow you that far for this reason. This specific issue has not been addressed, at least by any cases that either side here has been able to find. But restitution, which is what we're talking about, is a method of preventing or disgorging unjust enrichment, which is firmly grounded in equity.
Right. You know, counsel, I don't mean to interrupt you, but let me tell you my take on this because it might help you. My take on this is, under certain circumstances, a reduced judgment might not, the judgment debtor on a reduced judgment might not be entitled to full restitution because it's an equitable principle. But once restitution is made, once restitution applies, the interest follows with it. So the equity doesn't apply to the interest. The equity applies to the restitution. Okay. So and that's where I'm coming from.
All right. And I would endeavor to convince you the law is otherwise. Okay. Because we do have, even though this specific issue hasn't been addressed, there are Arizona cases, as well as everywhere else, that deal with equitable remedies. And the cases are consistent when addressing the specific issue of is there discretion or not, to always say, of course, it's an equitable remedy. Of course, the court has discretion to make sure equity is done. And in fact, in the Canal Insurance Company case, the court there was dealing with an issue of interest. It was interpleaded funds. And they said we're dealing with equity and whether interested. It's an equitable issue, so it's going to fall somewhat to the discretion of the court. I don't see in the case law a suggestion as to why there should be an exception carved out of the notion that courts, when doing equity, when trying to impose equitable remedies, lose their discretion when dealing with the issue of restitution and unjust enrichment.
But going back to Judge Kessler's question and your follow-up to that, I think the restatement supports the analytic framework he's suggesting, because Section 53 of the Restitution and Unjust Enrichment restatement says the availability of prejudgment interest is regulated by local statute and decisional law. Only in the absence of a statutory interest rate does it suggest applying equitable principles. And so it seems to make the distinction Judge Kessler is suggesting, which is the existence of a restitutionary obligation is equitable, but we're not dealing with that here. For whatever reason, the Nardellis conceded that they owed that amount in restitution, and then it becomes a question of statutory regulation, even according to the restatement.
But according to the restatement, each jurisdiction would have to look at its statute. And that takes us back to, you can't ignore, what does the statute say? The statute says there must have been an obligation or indebtedness. So,
but assuming that we say there was an obligation or indebtedness, then the interest is automatic, because the statute doesn't say a court may award interest in its discretion. It says here's what the interest will be.
I think then you have a tension between the statute on the one hand and the notion of an equitable remedy on the other. But
equity has to follow the statute.
Well, and I'm not here to argue that. Then you get into, is the statute clear, as the case law says, if law must trump equity, and was it liquidated or unliquidated? And
but if I'm trying a case in equity in the Superior Court and there's a judgment, and I, as sitting in equity, issue a judgment, that judgment triggers this statute. I mean,
a judgment triggers the statute, yes. I'm sorry, I didn't mean to interrupt.
But so that, to me, solidifies the notion that it's the underlying obligation, equitable obligation, that's subject to equity, and that then the statute applies once there is a judgment, obligation, indebtedness. And I mean, I think you've made some arguments on appeal that should have been presented in the trial court that would have perhaps been fleshed out, including the liquidated damages issue, but I'm troubled by the whole new tack on appeal.
Well, the arguments, again, really do come under the equitable arguments as we've been arguing all along, which is the Nardellis were the judgment creditor. They didn't seek a tender. They didn't say that a supersedis bond must be posted. They had been in litigation at that time for 8 years with this company on a 10-year-old covered loss that had never been compensated for. They had over $300,000 in outstanding cost in the case, and they accepted finally the tender after MetLife's insistence to try to mitigate some of that and hold aside and give back. And of course, you know, they gave back exactly the interest that they were able to earn on the money. So I've got 2 minutes and 20 seconds. I'm going to try to hold on to.
May it please the court, my name is Ben Cooper and I represent the MetLife defendants. First, I'd like to address Mr. Dawson's statutory argument and then address what he described as the new dynamic in this case, which I think is actually a very old dynamic that's governed by very well-established rules. The problem with his distinction between obligation and indebtedness, his statutory argument is, not only was it not made below, he didn't even make it on appeal. That was an argument introduced in the amicus brief from the Arizona Association for Justice. Their argument was below that statutory rate is simply unfair because it's more than my clients earned on the money by putting it in a lawyer's trust account.
What do we do with the principle that when we're trying to interpret a statute and apply a statute, we're not bound by the parties' arguments, that we can go beyond that because we want to make sure we're interpreting the statute correctly? Does that have any play in here?
I don't think it has a play here because if, and for the reasons we stated in our brief, it's not a fundamental issue of public policy because the parties could have contracted for a different rate. And essentially, so because the statute allows the parties to contract for a different rate, if a different rate occurs, that's not one the statute would have imposed. Here you get the same result because we said it's 10% and they did not disagree until they got an appeal and now they've dropped that argument.
But if the statute doesn't apply at all, shouldn't we, in interpreting a statute, not assume that it applies?
No, I think the rules on waiver apply in this situation. But I think the court does not have to get caught up on that because the statute clearly applies. And I think for the reasons we said in our response to the AAJ's amicus brief, it applies. The fundamental flaw in Mr. Dawson's argument is that he's confusing with the basis of the obligation with the statutory setting of the rate on that obligation. 44-1201 does not set obligations. It does not create obligations. It sets the rate for interest on obligations that have their basis somewhere else. So if in the Metzger case, it's directly analogous to Metzger. The court,
Can I interrupt you because I'm sure you know this, but Metzler was accepted for review by the Supreme Court. It was argued last week, and I don't know whether you've listened to that argument, but I have some hesitancy to go there on Metzler. Do we need to rely on Metzler?
Well, the question of Metzler is which of the two the real dispute is which of the two rates do you apply?
I don't know. Did you listen to the argument?
I have not listened to the tape of the argument.
I think one of the real issues is what do the terms indebtedness and obligation and loan mean?
But in this case, we have never relied on indebtedness. We have relied on obligation. And I think if you look at the underlying law of restitution, which creates the obligation. It's undisputed in this case that under cases like Ramey, Moore, the Supreme Court's decision in Markell, where there's a reverse judgment absent some unusual circumstances not presented here, there's an entitlement to pay restitution. That is an obligation. It may be a contingent obligation, but it's still an obligation.
Ramey does say something about, I can't remember, I think it's paragraph 21 or 22, does talk about that restitution is an equitable, the idea of restitution is an equitable principle.
Right. And that's whether or not to grant restitution at all.
Right.
But here there are no circumstances that would disallow restitution.
Not even before us because they made the restitution.
Right. And they never challenged their obligation to make restitution.
The only interest before is once it's conceded the restitution is owed, does interest follow the restitution?
That's absolutely correct, Your Honor. Mm-hmm. And both Ramey says that the party that paid the judgment is entitled, quote, entitled to restitution, including both the amounts paid and interest from the dates of such payments. The Restatement Third, Section 18, Common H, says the same thing, that the contingent obligation is created at the moment that the judgment is paid. It may mature later when it's reversed, but the obligation dates back. And that's what we advised them at the time. There is no case cited that says that the obligation to pay interest starts not at the date of reversal, but at the date of, not at the date when the payment of the judgment is made, but at a later date when the judgment is reversed. That judgment is running, that interest is running the whole time, much as in under Rule 68 in Metzler, which I don't think is an issue, the interest is running from the date of the offer under this underlying law, the date of the offer of judgment. And it continues even though it becomes actionable at the point when a more favorable judgment is entered later. The underlying obligation is still running on a contingent basis and the interest is accruing. But that's not fixed by the statute. That's fixed by the law of restitution, which has not been disputed here, which is that the right to interest runs from the date of the payment. That has always been the law, and there's no controverting case law that's been citing. Where the statute comes in is, since you have an obligation, it sets the rate, and it sets a rate of 10%. The argument that the plaintiffs did make on appeal in their opening brief, but then dropped in their reply brief, was they were trying to get out of the 10% rate and into the 4.25% rate for judgments. but Mr. Dawson now concedes, as they did below, that the 10% statutory rate applies here, and there are a variety of reasons why it has to. The only judgment in the picture would have been the original judgment that MetLife paid, and the enactment clause of the statute says it doesn't apply to prior statutes, to prior judgments rather. So there's no way it could have applied to that judgment. It is, in fact, an obligation earning interest, and since it's not a judgment, it gets the 10% rate that the statute applies to any loan, indebtedness, or other obligation. I'm not sure what the Supreme Court would take on. I've learned from my own personal experience that oral arguments are, your result may be further than it appears in oral arguments. So I have no idea what the court will actually rule. But I'm not sure what an obligation is if it is not this. It is a well-established legal principle that creates a duty to pay when an event happens, which is reversal, and a duty to pay interest dating back to the date of the payment.
But your threshold view is that we don't even have to resolve that because it was waived in the trial court.
I think it was waived.
And according to you, and I'll go back and look at the briefs, even waived because it wasn't raised in the opening brief by the Nardellis.
Correct. Their complaint in the opening brief was you should apply a different statutory rate of 4.25%, argument they dropped, or applying any statutory rate is wrong because this should be in equity. Arizona doesn't have an equitable rate of interest, because the statute is on point in setting a rate for all obligations. There's simply no law. And where you have a statute that's on point that fixes an entitlement, in this point, the statute fixes the entitlement to the interest, the 10% interest, not the entitlement to the restitutionary interest, then that statute's governed and there's no equitable departure from it. In fact, in the jurisdictions that have been cited, even in California, which has a specific statute governing this kind of restitutionary remedy, where the courts have been held to have some flexibility in setting rates, they have, as in the Cussler case, resorted to the statutory rate, or in that case, the constitutional rate, because if you don't go by the statutory rate, then you're at sea as to what rate to use in that kind of situation. What is the market rate? It depends how you measure the market.
Counsel?
Yes.
What about the opposing party's position that it's easy to determine what should be the appropriate rate, no more than what we received?
Well, but that no court has ever adopted that. And think of the perverse incentives. So if they had rolled the dice and put it into Apple stock and made it a 30% return, so would that be the measure of the interest we would get, 30%? Or it creates a perverse incentive to say, I want to take the money and have the use of it on appeal. I don't trust the defendant. So I'm going to take the money, accept the tender, and just put it with no risk to me and no compensation to the judgment debtor by simply putting it in a IOLTA account, because I have no risk. And that's not the dynamic that the law has created.
Do we need to be concerned about, I think what counsel would assert to be the inequity of the overpayment resulting in them paying a higher rate of interest on return than they received?
No, there is no overpayment and there is no new dynamic, as Mr. Dawson put it. This is a very old situation and it's balanced and fair. The judgment debtor, in this case the MetLife defendants, had the ordinary choice of all judgment debtors. You could either pay 10% pre-judgment, post-judgment interest, even though it's much higher than the market rate, or tender the amount. And if you tender, it cuts off interest immediately. So we had no interest in their accepting the tender once our objective was met the moment we made the tender. That cut it off. They then have a balanced reciprocal choice to make and a reciprocal risk. As a judgment creditor, they can either take the money and risk owing interest back at 10%, the statutory rate, or they can simply decline the tender and proceed to litigate it, in which case neither party, no money has changed hands, and no party has incurs any interest at all.
So you're saying there was no penalty that attached to them by rejection of the tender?
Absolutely no. And in fact, lest there be any confusion about this, we went out of our way when we were litigating before the Superior Court the first time the sufficiency of the tender to say, look, you said you don't want to be our banker. Fine. No one has to be anyone's banker. All you have to do is continue to reject the tender as they already had. Remember, they rejected the first two tenders, and we proceeded to litigate the case. And after the amended judgment came in, we then filed a motion saying, would the court please recognize that our post-judgment interest obligation has stopped? And they said, well, that's not fair because then we're your banker. And we said, no, just continue rejecting the tender. No one's anyone's banker. And we proceed to litigate it. The law is well established, and they never argued to the contrary that somehow that they had waived our underlying obligation by rejecting the tender. It's well established that all you waive is an entitlement to interest for the person not having paid it once the tender is made.
Can I ask you,
certainly.
It's a housekeeping clerical issue, but
Certainly.
I see it as a problem, and I don't know what we should do about it. It relates to the judgment on mandate that Judge Flores signed.
Yes.
Neither of you has raised this, but one of our eagle-eyed panel members caught the fact that her award of prejudgment interest on the award of restitution at the statutory rate of 10% from July 22nd, 2010 through July 18th, 2010.
We noted in a footnote there was apparently an error. There's a later point.
2012, right?
It should have been. We actually have a footnote in our brief where we say that was apparently a mistake, and that later in the judgment the court gives the right date.
The court later, so it's been amended, and we don't have to
Well,
worry about
it's not been amended, but in that very judgment there is a later point where the court gives the 2012 date. It's clearly
as long as nobody's concerned about that, because
I
that's
don't think
clearly
it
an
is.
erroneous date.
We prepared the form of judgment, so that's on us. But the second time the date's mentioned is correct.
Correct. Okay.
We're
not worried.
So in this case, even if the statutory rate is higher than what either party could have made, each side has a fair and open chance to avoid having to pay any interest while the appeal goes on, and that is we tender it, that gets us off the hook. They reject it, that gets them off the hook, and it doesn't change anything about the underlying case. And that was the very point we made in citing Miga versus Jensen, the Texas Supreme Court case, in that that was before they accepted the tender, and trying to clarify, hey, you don't want to pay us, hold our money? Fine. That doesn't change anyone's thing. Now, why they then took the money that was entirely their decision. But they did it after we went out of our way to explain why you don't want the tender, fine. We've achieved our purpose. You don't have any risk. We go do it. That may be a fully rational choice, particularly when there's no issue about MetLife's ability to pay the judgment if it's affirmed, and there never was any issue. In this case, by making that decision, it was entirely self-inflicted because they had no reason to accept the tender if all they were going to do was take the money and put it in a non-interest-bearing account. If they didn't like the spread that was apparent between basically zero on an IOLTA account and a 10% statutory rate, they should have then not taken the money. If they were going to put it in a high-yield investment, that was their call. If this were the late 70s, where the market interest rate was a lot higher than the statutory rate, it would have been a different bet. But as I think one of the cases we cited in our brief says, that's a wager you make. Am I going to do better with the money than I would have done if I had rejected the tender? And you just have to guess, make an estimate of your chances of appeal. And if you don't like the wager or you're risk averse, just don't take the tender. It doesn't affect the underlying case. Unless the court has...
So your position is we don't have to worry about equity because they could have avoided it entirely. In not having avoided it entirely, they are subject to statutory interest.
That's correct. There's no reason, going back to the Henry versus Mayer case of the Supreme Court during the territorial days, equity doesn't intervene to protect people from their own unforced errors, as it were, their own imprudent decisions that the other side had no part of. In fact, we were in court papers telling them, look, you don't want the interest rate, don't take the tender, we'll then wait the outcome of the appeal. They knew full well that they were not losing anything, and they never suggested to the contrary that they had somehow lost anything. They wanted the money pending the appeal, and that came at a price which we warned them of 4 times.
Well, you did warn them, but there is a penalty to be paid if they reject the tender, which is assuming that we affirmed the judgment, they don't get any interest. Post-judgment interest. It's gone because you made the tender. So, I'm just hypothetically, the penalty to them of saying we reject the tender is they automatically lose 10% interest.
Well, but the 10% interest isn't a penalty as much. And Mr. Dawson said
the penalty is I lose that by rejecting.
By rejecting, you have a choice.
Still make the choice.
At the time they made the decision about whether to accept the tender, post-judgment interest was gone. Because the moment we made the tender, it was off. So they weren't going to get it. We had fulfilled the obligation to make the money available. It's then entirely their choice and it's a risk assessment, cost-benefit analysis that they go through.
Losing 10% or losing 9.85%. I mean, in essence, they just made the assessment, but they really didn't have much of a choice, because either they accept it, either they don't accept it and they lose the 10% post-judgment interest, or they accept it and decide what to do with it in the meantime in case there's a infirmance or reversal or a reduction.
Actually, I think the 10% isn't even part of what they lost, because the 10% is already gone at their decision point. So all they're choosing for is, do we want whatever we're going to invest it in, with a risk of having to pay 10% back if we're wrong about affirmation of the judgment. So that's really the 10% you're balancing against. But again, that's all their choice. We have, in a sense, no skin in the game at that point, but we certainly had no way to force them to make a decision. We tendered 3 times to meet their objections to make sure we had a valid objection.
It's a no-brainer to say, if I'm going to lose the 10% interest anyway, post-judgment interest anyway, I might as well take the money and do something with it.
I don't know about that. If, in fact, your investment's going to get you 0.1% interest.
Well, it's better than 0. Because if they let you keep the money after the tender's been made, they get 0 interest on it. So they might take it. I mean, I don't say that. I'm not saying that affects the result.
No, but it's a risk assessment. It's not. Sure. It's 0. You're right. 0.1 would have been better than nothing if it came with no risk. But the whole point of this ancient dynamic is the risk is one of reversal and appeal. Right. And remember, it's in the record. If they had wanted the entire 1.5, they could have walked away from it. They made the decision to both accept the tender and appeal, which is what triggered the cross appeal. In this case, given that they have not pursued the liquidation argument, our position is liquidation is really not required at all, because under Markel versus Transamerica, in this precise setting, where since you're presumed to know of all the errors in the record, it's all fixed. And these 4 amounts were all calculable and known. The issues were all liability, and that doesn't make something unliquidated. And finally, I think the issue of the 4.2 judgment, 2.5% rate doesn't apply until the judgment gets entered below. And there's been no dispute about the interest rate that applies once the judgment's been entered. Unless the court has any questions, I will sit down.
Thank you, counsel.
Quickly turning to this last point that Mr. Cooper made about the amounts were calculable, and I guess it's their argument that they were liquidated. Given their briefing and given the history, that's not really believable. They said in their answering brief, they pointed out that one of the letters that they're trying to tender their money, that they had stated that if the MetLife would not cross appeal, the matter would end with the MetLife's payment of the judgment. So to try to suggest that it was choosing to pay $683,000 more than it knew or believed it would owe, I think defies the suggestion that this was calculable, it was 1-to-1, we all knew it was going to be reduced. Yeah.
I mean, if we start getting into the issue of whether it's liquidated or not, it sort of reminds me of attorney's fees. Attorney's fees, there's a lot of discretion about whether a court's going to award the amount of attorney's fees requested, and usually that's not deemed a liquidated damage for prejudgment interest. It seems to me this would be the same. I mean, if that doesn't apply to attorney's fees, the amount of attorney's fees shouldn't apply to what an appellate court's going to do on whether a punitive damage award should be affirmed. The problem is, was it made? To me, the real problem was it made? The argument made below.
Another point I wanted to rebut is that there was some discourse about the risk. Or was there no risk? Did the Nardellis think there was no risk by taking it? Well, of course, the Nardellis always knew that the risk was if there turned out to be any unjust enrichment, it would have to be disgorged. And this goes to counsel's citation or discussion of the Crusader versus Crusader case, the California case in both briefs. There, the court reiterated the principle that, quote, the court may in its discretion award interest on the amount of restitution. In general, interest is awarded unless it would be inequitable under the circumstances, consistent with the notion of what's going on here, which is unjust enrichment and disgorgement of it. counsel talks about, well, let's think of the perverse result. What if they had been able to earn 30% return on their money? Well, I think that's what equity is designed for. If, in fact, they would have been able to earn 30% return on their money, then I think under equitable remedies, they would have an argument that you were unjustly enriched by that amount, and that has to be part of what's disgorged from you. That's exactly what we're suggesting. Finally, I just want to go back to this, that at the end of the day, MetLife is asking you to apply a statute, but to do so by turning a blind eye to the terms of the statute. And I understand they're saying, well, they've waived the right to ask anybody to read the statute. But I think, given the general argument that's being made, that this statute is what controls the day, read the statute, it will inform you it controls the day, that you have to apply the terms of the statute.
Thank you, counsel.
Thank you.
All right, oral argument is concluded at this time. We are taking the matter under advisement. A ruling will issue in due course. Thank you.